Hi, I'm attorney Rilus Dana. In this video, we'll be discussing estate planning for relationships. We're going to talk about community property. So if you live in Arizona, California, Nevada, or any of the other community property states, this video is for you. If you're currently married, plan on getting married, engaged to be married, or even if you're cohabitating with someone, this video is for you. So let me share my screen here. So this is where I practice law in Arizona and California, Dana and Associates. You can reach out to me there if you need help with your estate planning or probate in Arizona and California. Okay, so here's our friends, Mr. Estate and the soon-to-be Mrs. Estate. So estate planning. So estate planning is about what happens upon death. And that's the primary focus of my business as an estate planning attorney. I help people plan for their assets upon death. Very similar to what would happen if a relationship ends during life. Now, the reason estate planning is important and the reason we're starting with that is because the estate planning is going to affect how you hold assets. I'm going to recommend that assets are held in a trust. So a trust is a document. The person that makes it is a trustor. The person that manages is a trustee. And the beneficiary is the one that receives. So usually the person that creates the trust is all of those things. And then they designate their successor trustees and their beneficiaries, and they outline the terms of the trust. But the trust is going to hold your assets like real estate, bank accounts, and investments. So what happens upon separation? So estate planning is all about what happens to assets upon death. So if you're in a relationship, I recommend in planning for the assets, not just for estate planning, but how's it going to work during the relationship or if the relationship ends. So if you plan to be married, the community property rules are going to affect you, and we'll get into that in just a second here. If you're living together, then even though you don't plan on getting married, these rules still may be implied to you, or there may be other things to consider. All right, so what is community property? In Arizona, the Arizona law defines it as all property acquired by either husband or wife during the marriage is the community property of the husband and wife, except for property that is acquired by gift, devise, or descent. So basically, all property acquired during the marriage is community property except for gifts. All right, so Mr. Estate here, he's got a bank account. He owns a house. So that's his separate property. Now, before you're married, of course it's a separate property. And then Mrs. Estate, she's got a bank account and an IRA, also her separate property. They get married. And then the community is created at that point. So from this time forward, anything that's acquired by them is now considered community property. So let's take a look at this. So income from job, Mr. Estate goes to work, he receives a paycheck, and he deposits this pay marriage. So technically, even though he deposited this into a separate bank account, the portion that he earned during the marriage is community property. So you have a duty to trace back separate property. If you want to say that it is your separate property, you have to show the origins of these funds and where it came from. So income from work is not community property, but whatever Mr. Estate had in this bank account before the marriage was his separate property. All right, Mrs. Estate, she goes to work too. She puts all of her money, all of her paycheck into her IRA. So same thing. Even though it's in her IRA, the community has an interest for this portion, the portion that was earned during marriage. So that's something that I see quite a bit where people will think that they have separate property, but if the assets have been acquired during the marriage and without a premarital agreement opting out of these default rules, it's going to be their community property. All right, so he sells his house. They buy a house together as community property. They open some bank accounts together as community property. And let's take a look at what happens to inheritances. So Mr. Estate, his parents pass away, and he's the beneficiary of their trust. Now, if he receives his inheritance and he deposits it into a community bank account, then transmutation, the nature of that property has just been changed from what could be his separate property to now the community property of both of them. If that bank account or if his inheritance was placed into a new bank account, so it's clear to see that the origins of this money was from the inheritance, then that will be his separate property. So something I see quite a bit as well, where there's the potential to hold assets as separate property, but once they're mixed with the partner, then they become community property. So gifts, so everything besides gifts are separate property. Everything besides gifts are community property. And if you want to have separate property, you need to keep it separate if there is a gift. All right, so what I recommend for couples is that you define the terms of your relationship. And here's one reason why. So what happens to the growth of separate property assets? So what if you have some assets, especially a business? If you have a business before marriage, that could be an ownership in an LLC, could be a real estate business in this case. So what happens to the growth of that separate property assets over time? So this example, Mr. Estate has a few rental properties. Over time, they grow, and then the relationship ends. So the question's going to be this. So was the growth over here related to the efforts of Mr. Estate? Was he active in this business? If so, then the community may be entitled to some of that growth because he doesn't exist, right? He's not going to work. The community is going to work. So if his efforts related to this growth, the community will have an interest in that. Now, the other test or the other way it could go is that this was just a passive investment, that the growth was unrelated to Mr. Estate. He wasn't spending any time or efforts into this business and just held it passively. If that's the case, then all of the growth is still going to be his separate property if the relationship ends. So the reason I recommend a written agreement is to avoid questions like this, and especially at the end of the relationship. That's not the time to be able to solve these questions, because once you lawyer up, they could argue either way. So the point of the written agreement, or the real value of it, is to try to avoid that. Define the terms of your relationship. So if you're going to be married, that would be a prenuptial agreement, also called a premarital agreement, also called a prenup. All the same thing, but what it does is it allows you to opt out of these default community property rules. It allows you to clarify these questions of what happens to assets if the relationship ends. Really important if either party owns a business or owns separate property before the marriage. Now, if there is no plan to be married, but you're living in a house together, a cohabitation agreement is a good idea, clarifying who the owner of the house is and whether the other party is gaining ownership, and just defining how it's going to work, who's going to pay for what. So there's good value in that for couples. So here's a way to do a prenuptial agreement. So it's got to be a written agreement. You cannot waive child support obligations, but you can waive spousal support obligations. So you can opt out of all of those rules and define what would happen. Part of the prenup is you're going to disclose assets and debts. So you make it clear what you own and owe, so both parties can determine that and know what they're getting into going into the relationship. You need some time. This shouldn't be done the night before the wedding. You need enough time to make sure that both parties understand it, and they really need to be represented by counsel. In order to prove that each party actually understands what's going on, the only way to do that is to have an attorney explain their rights to them in the document. And prenuptial agreement, premarital agreement, that does mean before marriage. The marriage is the consideration of the contract. So the parties in consideration of marriage enter into this agreement. If this is done after marriage in something like a postnup, it's my opinion that those documents have little to no value. It really needs to be done before the marriage. Now, there may be some things that you can do to try to separate things once you're already married, but again, you're already in those default community property rules, and the marriage has already started. So it's best to do this before the marriage happens. All right, so what I recommend for couples, the formula is this: an estate plan plus a written agreement equals a plan for success. So I hope you found that helpful. If you have any questions, you can leave them below in the comments. Any future videos that you'd like to see, leave those in the comments. I'll leave a link to rilusdana.com. You can find all of my other websites and social medias there. I'll see you next time.